Hi, I'm Katherine Fry, and today I'm going to fill you in on the provisions of Delaware law dealing with discrimination, including sexual harassment. The Delaware Discrimination in Employment Act, or DDDA, which is in Delaware's law prohibiting discrimination of many protected classes, applies to employers with 4 or more employees, not 15 or more, 4 or more employees. The owners of the company themselves are counted among the 4. So almost every employer in Delaware has to be concerned about those laws, not just to employ 15 or more as specified by federal laws. In Delaware, the following are protected classes. Get ready, it's a long list. Race, marital status, genetic information, color, age over 40, religion, sex, including pregnancy, national origin, sexual orientation, gender identity, status as a registered qualifying medical marijuana patient or designated caregiver, volunteer emergency responder, handicap, domestic, sexual violence or stalking victim status, reproductive health decision, and family responsibilities, which are the obligations of an employee to care for a family member who would qualify as a covered family member under the Federal Family Medical Leave Act, FMLA. Notice that Delaware law covers a number of protected classes which are not addressed by federal law. Significant among these are sexual orientation, gender identity, status as a medical marijuana card holder, emergency responder, crime victim status, and those who have family responsibilities. Basically, no negative employment action may be taken based on any of these characteristics, in addition to those protected by federal law. Later on, I'll discuss a few of these cases. For now, let's talk about the 2019 Delaware Sexual Harassment Law. The law is an expansion of the DDEA. Like that act, it also covers employers with at least 4 employees within the state at the time of an alleged violation. The state, the General Assembly, state agencies, and labor organizations are all included in the definition of employer. The new law expands the types of workers covered by the DDEA to include state employees, unpaid interns, applicants, joint employees, and apprentices. The new law clarifies that sexual harassment involves conduct that includes unwelcome advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. Such behavior rises to the level of an unlawful employment practice if submission to the conduct is a condition of employment, either explicitly or implicitly, is the basis of employment decisions, unreasonably interferes with an employee's work performance, or creates an intimidating, hostile, or offensive working environment. That's how the law phrases it. The statute makes an employer liable for acts of sexual harassment when the employer knew or should have known of the harassment and failed to take corrective measures, and harassment by a supervisor results in a negative employment action against an employee, or when a negative employment action is taken against an employee in retaliation for filing a discrimination charge, participating in an investigation, or testifying in any proceeding about sexual harassment. A negative employment action is expansively defined to mean any action taken by a supervisor that negatively impacts the employment status of an employee. Depending on how this term is interpreted by agencies and courts, this definition could theoretically cover a wide range of employer decisions, perhaps wider than currently encompassed by the federal framework. Notably, the definition of employee is also quite expansive. Under the Delaware law, an employee is an individual employed by an employer and includes state employees, unpaid interns, applicants, joint employees, and apprentices. The Delaware statute's inclusion of unpaid interns, applicants, and apprentices in the definition of employees sets it apart from the sexual harassment laws of other states. Under the new law, an employer can avoid liability for harassment by a non-supervisor by proving that, number 1, the employer exercised reasonable care to prevent and correct any harassment promptly, and number 2, the employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer. This should sound familiar. It's exactly like the federal standard. The availability of the defense highlights the importance of addressing these issues of sexual harassment that come to the employer's attention, by whatever means, in a prompt and thorough manner. This is where the anti-harassment policies come in, to establish the employer's defense. Now let's talk about training requirements in Delaware. While many states have laws encouraging employers to provide anti-harassment training to their employees, Delaware now joins the short list of states that require sexual harassment training for employers with 50 or more employees, including interns, etc., as I stated earlier. The training for staff must include all of the following elements. 1. The illegality of sexual harassment. 2. The definition of sexual harassment using examples. 3. The legal remedies and complaint process available to the employee. 4. Directions on how to contact the Department of Labor. And 5. The legal prohibition against retaliation. In addition, the interactive training for the supervisors must further include all of the following. 1. The specific responsibilities of a supervisor regarding the prevention and correction of sexual harassment, and 2. The legal prohibition against retaliation. The new law does not mandate the length of the training, but only that the above areas are fully covered during the training. Employers don't count applicants or independent contractors towards the 50 employee count. Employers are not required to provide training to applicants, independent contractors, or employees employed less than 6 months continuously. Employment agencies are the only employers required to count and provide training to employees placed by the employment agency themselves. Employers who provided training that meets the requirements of the law before January 1, 2019 will not be required to provide additional training until January 1 of 2020. How often must employees be trained? Training must be conducted for new employees within 1 year of the commencement of their employment. Existing employees must receive sexual harassment training by January 1 of 2020. New supervisors, new hires, must receive additional interactive training within 1 year of the commencement of their employment in a supervisory role. Existing supervisors must receive training by January 1st, 2020. This supplemental training for supervisors must cover the specific responsibilities of a supervisor in preventing and correcting sexual harassment, as well as the legal prohibition against retaliation, as I said earlier. These employee and supervisor training programs must be repeated every 2 years. I should also add that it's not okay to just have a video presentation. This you cannot broadcast to your employees. This will not work. It must be something interactive. We don't know exactly what that means, but that's what it says. Be sure to create a system to track who's been trained and when. It's unclear whether a worker could complain that he or she was not trained. You don't want to go there. The new law also contains a notice requirement. Under the new law, Delaware employers of four or more employees must give notice to employees of their right to be free from harassment at work via an information sheet which was created by the State Department of Labor. Employers must distribute the information sheet, either physically or electronically, to new hires at commencement of employment. Employers must provide the notice to existing employees by July 1, 2019. One easy way to keep track of this distribution is to make it a part of the employee handbook. The handbook should always have a page for the employee to sign, acknowledging receipt of the handbook. Now just add the sexual harassment notice to the receipt. The notice is available on the DOL's website. However, a word to the wise, my colleagues and I spotted some mistakes on the notice, and the DOL says it will be correcting it in July. At that time, employers will need to download the new notice and distribute that. Note that the DOL may be contacted through its website or via phone or mail, as stated on the website, and a charge of discrimination may be filed via the website, via mail, or by going into person to one of its offices. The harassment training has to cover this with employees, and everyone should know this information. I recommend that the interactive training be provided by a professional HR person or an employment attorney. This is the last presentation an employer wants someone without specific knowledge to give. I try to have a session where it's a conversation and make it interesting and therefore more memorable for the participants. My last piece of advice is this. Do not rely on a video for this training. It's pretty clear that it would not meet the requirements of the law, as I said before.